Good afternoon, everyone. Welcome to our webinar today from the First Ally Trustees team. We're very excited to have everyone here on board today, and we welcome you here to this webinar that we believe will be an insightful event. Not only will it be insightful, but we hope that at the end of the webinar, we all have some tools that are necessary for us to protect what really matters to each and every one of us. And with further ado, I will be welcoming the trustees team. Today we have members of the trustees team. We have our trust manager on board, Nwamaka, as well as the MD of the First Ally Trustees, Adetola Adele, and they'll be speaking to us today on how we can protect what matters best to all of us. So I'll be handing over to Nwamaka to take us through the session. Thank you very much.
Good morning again, everyone, and thank you so much for joining us today on what promises to be a very enlightening session. It's truly a pleasure to be here today to talk about a subject that is not only strategic, but is deeply personal, protecting what matters, building legacies through trust and estate planning. Now, in a world where there's so much uncertainty and the uncertainty is always is a constant. Taking intentional steps towards planning for the future is one of the most empowering things that we can do as individuals, not just for ourselves, but for generations that follow. They say that there are two most important dates in a man's life. The first one being the day he's born, and the second one being the day he discovers purpose, the reason for which he's born. But we'd like to add a third one, which is the day he dies, because the day he dies, his legacy is sealed, and the choices he has made, what he leaves behind, now begins to speak for him. Today, we will explore how trust and estate planning can help you protect your assets, how your values, how to honor your values rather, and how to ensure that your legacy outlives you clearly, securely, and with purpose. So, in addition to making money, which is what we always, what we always speak about, making money, multiplying money, and all of that, today we'll now go deeper to now speak about how we can secure our legacy. Aside making wealth, growing wealth, and making our monies work for us, we are going to speak today about how to secure our legacies, how to preserve it, how to ensure that when we are not here, whether in case of death or incapacitation, our money, our legacy, outlives us and speaks for us. So before we dive into the heart of today's topic, I'll take a quick overview of who we are at First Ally Group. I believe the slides can come up now. Okay, just give me a minute. All right. I'm sorry, we're experiencing some network failure, so the slide will go up any moment from now. But whilst we wait for that, I'll just go into the session so that we can, start engaging. So First Ally Group, our corporate philosophy and our vision most especially is to become a partner of choice, providing innovative financing solutions and enabling growth. Our mission is creating opportunities that foster growth, and our core value as a group consists of trust, integrity, client focus, teamwork, innovation, and professionalism. As part of our group, or we have First Ally Capital as the holding company and subsidiaries as First Ally Advisory, First Ally Asset Management, First Ally Trustees, which is the business hosting this webinar today or championing this webinar today, First Ally Properties, which is our real estate division, and First Ally Trust Microfinance Bank. So, about our group, we we pride ourselves as a one-stop shop for financial services. We have 100 plus years of combined management experience, 10 years in existence today. This year will make it our 11th year in existence. So we're a solid group. We've been around, and we have 148 billion in AUM from our asset management business. Um, First Ally Trustees is licensed by the SEC. We are licensed to offer comprehensive trust services, but most importantly, we built around one idea, which is protecting wealth, which is as important as creating wealth. It is a strategic step to take as you protect, as you build, as you grow, and as you protect your wealth. Even creating plans and steps that makes it worth the while, makes you have that legacy is even as important as creating it in the first place. Our core focus at FATL, First Ally Trustees, is trusteeship. We specialize in the business of trusteeship with three umbrella products, which is the private, public, and the corporate trust. We serve as independent parties in financial and non-financial transactions. And for us, it's not just about ticking the boxes, it's about providing stability and stewardship for what really matters to individuals. Okay, now we'll go into the heart of today's topic, which is preserving your legacies, protecting what matters, and building legacies through trust and estate planning. Protecting what matters and building your legacies through trust and estate planning. I'm sure some of us may have heard the term estate planning, trying to wonder what is it about, we just know it, don't not really don't have details, but we understand or we've heard about people talk about it, people talk about wills, which is the most common one. And what does it really mean to have an estate plan, to create an estate plan? It's simply putting your house in order, just in a simple way. In simple definition, is putting structure around all what you have, all what you own, and most especially how it affects who you love and how you want to make sure that everything is watertight, it takes care of them, whether you are here or you're not here. And then there are questions that will come to your mind. Oh, how do I ensure that my wealth continues to serve my family even when I'm no longer here? How do I avoid conflict, which is what is on the mind of most people? How do I avoid conflict, confusion, or delays when transferring my asset to my next generation? We'll speak about how we can use several tools to avoid conflict, to avoid confusion. I also give you typical examples, life examples of people who have, picked plans, created plans, and how best you can align a plan to fit your specific situation. One other question that you may also ask ourselves is, can I protect my values, not just my valuables? Can my legacy live years after I've gone? The things that I stand for, the things that I believe in, that they know me for whilst I'm alive, can they still know me for those things whilst I'm gone? So these are the questions I know that a couple of people have, going on in their mind. And this is why we've organized this type of webinar to ensure that these questions are answered. We can carefully design structures that can preserve your purpose and protect your legacy and ultimately answer all these questions and concerns. Now, how do you plan an estate? There are different tools you can use to plan. Recall I said that it's a way of putting your house in order, putting a measure or putting a structure around your wealth, around who you want your wealth to go to, deciding what should happen in the event that this happens, a circumstance happens. So that's the idea of what an estate plan or what estate planning as a concept really is. Now, how do you plan your estate? There are different tools. You have gifts, you have power of attorney, you have trusts, and you have wills. Some other climates will put maybe medical directive, which typically should fall under power of attorney. But for today, we'll just stick to these four tools: gift, power of attorney, trust, and wills. Now, I'll just explain briefly what each tool is about and what circumstance you might choose to use any of these tools. Now, a gift is a voluntary transfer of property to another person without compensation. Okay, I have this property. You mostly see it in the climate where people have landed assets. You want to give your property to your children, maybe whilst you're still living. Some people do the deed of gift and post-date it. Okay, then it takes effect after they're gone. So, but the general idea is you're gifting that asset to that beneficiary in your lifetime. You're saying, okay, I'm going to just I don't want wahala. I've seen people's character. People look like troublesome people. People look like people that will fight each other. People look like people that will say, okay, why did he give me the one in banana and he gave my sister the one in Chevron? So instead of that, I'll say, okay, I'll do a deed of gift and share it in my lifetime for you. There's that option. And we like to always advise clients, you need to examine your circumstance, your family circumstance, your unique family dynamic before you pick a tool. So if it's not going to work, if leaving them with the assets whilst you're not here is not going to work, and you feel this other way is going to work, then a gift will work. I used to say, if you know that the child is not going to sell the house you are living in on top your head, so to speak, then you can use a deed of gift. Then you go to power of attorney. Now, what is a power of attorney? It's just a document or an instrument, a legal instrument that authorizes somebody to administer your affairs on your behalf as you ordinarily would do it. So it could be maybe you're abroad and you have affairs that would require maybe your physical sign, your physical presence, and it's not something you can be running down. Maybe you have a property that you're managing. You can execute a power of attorney, appoint an attorney to act in your stead, but the limitations for power of attorney, excuse me, the limitations for power of attorney is it doesn't deal with distribution of assets after the person has gone. It only deals with you because it elapses once the person who has granted it dies. So that's it for power. So when you speak to, it could even deal with things like medical directives. Oh, okay. I would want them to leave me on life support because I'm in there. I know I'll come out of it. I want them to not waste time. I want them to do this. I want them to do that. Whilst you're still alive per se, the attorney can act in your stead and take decisions, unlimited decisions, as you would ordinarily do. Then you have the will, which I believe most people know about. It's a legal document which a person directs what will happen to their assets after their death. But with a will, it takes effect only when the person passes. So it doesn't necessarily deal with incapacitation. It's ambulatory in nature and it takes effect when the person passes. So when the person passes, there's a whole process, the reading of the will, the application for what is called a grant of probate at the courts, the registry, the Department of Probate at the High Court of Lagos. And then you now have a whole process of them now putting everything all together in paper, going for the courts, the probate registrar to now verify. You pay estate duty, and then they give you a grant before you can now have access, or rather, before your beneficiaries can now have access to your assets. Now, um, trust, which is the fourth one that we spoke about. Trust it's like a living will, if you allow me to put it that way. It takes effect whilst you are still alive. So I'm saying, okay, I have houses, I have stock, I have cars, I have jewelry, personal effects, I have cash equivalent, and I put it down in a trust deed. And I say, okay, if I'm on the way to Djibouti and I have an accident and I'm in a coma, this and this and this and this is what should happen. This is who you should call. If at that point in time they need to pay school fees will be paid by my trust. Nothing will be interrupted. My children will still go to school if I'm in coma for 5 years or 5 months or 5 weeks. My affairs can still run as if I am there. So think about a scenario of something that works for you whilst you are there, something that also works for you whilst you are not here. So think about that kind of scenario. That's what a trust will do for you. A living trust, as I've called it, is a legal instrument for administration, management, and distribution of assets. Is you transfer the title or you transfer your assets into a vehicle, and then you give the right to hold and administer those assets to a third party, a neutral third party, who is a trustee, like FATL, to now manage for you. The assets could be stock, real estate, movable assets, whatever. Think of it, whatever is of value and can bring value to your beneficiaries or value to you and can turn into some form of value to your beneficiaries is what you can put and consolidate under a living trust. The benefits of a living trust are enormous. One of it, which is what we like to highlight, is that it avoids probate. So when you compare it to a will, it avoids probate totally. You don't have to go through the court process to apply for a grant to be able to administer or to be able to now enjoy those assets. The beneficiaries don't need probate at all. So in a way, when you say it avoid probate, you also say that you avoid SADC, that 10% tax that they would value on the value of the entire worth of the. So the person, if the aggregate total value of the person's worth is 10 billion, they will collect 10% of that. If that's what they value, the houses, the money in the banks, the investments, the stock, everything, if it's worth 10 billion, your beneficiaries will be made to pay 10% of that 10 billion as estate duty. Now, unlike a will, there's no issue or there's no talk about public, it's become public knowledge and all of that. A trust is, it ensures privacy and confidentiality. So if you're somebody who, I met a client, I think earlier this month, he said he doesn't trust anybody. The only person he trusts is his mom. And well, it is the wish of every parent that, they die before their children will bury them, basically. So he doesn't trust anyone. He doesn't think he can transfer title of his assets to anybody. He doesn't think he can give any child in his lifetime any gifts. He basically doesn't feel comfortable trusting any. He has a hard time trusting anybody as part of his character and then his experiences. So for someone like him, he can just simply do a will. He's not bothered about privacy. There's nothing he's hiding. He's not really big about confidentiality. So he can do a will. But with a will, you have to do other things that follow. So whatever plan you choose, like I earlier mentioned, must suit your own dynamic, your specific family dynamic, your personality, first of all, and then considering who your beneficiaries are, their character traits, or do they have spendthrift tendencies? Those are the kind of things you should consider when picking a plan. So we're speaking about how you can build your legacy through trust and estate planning. And speaking about trust, continuing to talk about the benefits of a living trust. It provides assets protection and security. It offers flexibility and control. So you can easily amend. You can easily amend the terms as your life circumstances begin to change. So with a will, you would have filed at the probate, you lodge a copy at the probate, and every time you want to amend, if you register or you create a codicil and then file again at the probate, you pay costs and all of that. A trust is easier, is more flexible. You can easily say, okay, at the time I created this trust, I had 2 children, now I have 4. I want to include them specifically and I want to give specific gifts to them. You have additional assets. I want to now channel this part. Or this child has now fallen out of luck. I've seen situations where the settler will now say, I told my son, the settler told the son, don't marry this lady. And the guy went ahead to marry the lady, and he called the trustee to say at the time and said that we should remove him from the beneficiary list. And it's a thing that can happen. It does happen from time to time. So there's that control that you enjoy when you are, you pick a trust as your estate plan. So one important thing again is it allows you or it facilitates incapacity planning. So in terms or in case of incapacitation, maybe it doesn't really happen in this kind, but overseas, you see or you read or you watch in movies situations where, okay, the person is on life support, one family member is saying, let them go, the other family member is saying, I think he's still there, let's keep them, and they begin to fight and they quickly go run to court to see if they can get an order, get the court to rule on it. They file a motion and get the court to rule on it to say, oh, this is what the step should be. Now, with a trust, you can bypass all those kind of drama, all those kind of wahala, because it factors in situations of when the person is incapacitated. It ensures smooth management of assets without the need of guardianship proceedings, which, like I said, you see mostly abroad. It might happen here, but it's not as common. But with a trust, you can bypass all of that. Reduces tax liabilities. A properly structured one will manage your tax liabilities. Ensures multi-generational wealth transfer. A living trust allows for strategic estate planning, ensuring that assets are preserved and passed down from generations. And it can include provisions for charitable giving, philanthropy, such as, oh, okay, a portion of this money or this portion of this interest should now move to this charity or these foundations that have created, and the foundations will now cater to maybe school fees of people or cater to indigent women, things like that. A trust allows you to do that easily. Now, there are different products that we can coin depending on each person's unique circumstance. It could be dependent trust, it could be education trust. Education trust is one beautiful product, that helps parents. If you're worried about the fact that, within the space of, I think, 3 months, I've met parents who are way older than their children, not because of, they didn't want to have it. It just happened, life happened, and you see them in their 60s, in their 50s, and their children are less than 10. One that was 60, her child or her children are less than 15. In those kind of circumstances, I know that any reasonable parent will be worried. If I drop dead now, what happens? Okay, I have a mutual fund in their name. I have assets. I have, you're thinking, you're wondering, who will take care of these children if I'm not here? Okay, if I give money to this person can die. Now, I'm going to infuse something which is the role of a corporate trustee. It's a corporate entity. Not to say that individuals cannot be trustworthy, but you want to pick a partner, an ally that will be there, that would you won't have that issue or that worry of individuals. Okay, what if the individual even dies? Because there are situations where the individual will even die before the person who set up the trust in the first place. So if you're worried about things like that, an education trust will work suitably. Their situation because it is structured in a way that there's uninterrupted funding for the beneficiary's education, covers tuition, covers related expenses, accommodations, stipends, transportation, the way you would want it to be if you were here. So depending on what your objectives are, we can now recommend or do a dependent trust if you have children with special needs, you have aged parents, because some some people maybe illness and maybe accidents, unfortunate incidents, they die and they leave elderly parents. I know somebody who died, I think last year, he was 39. He already had children. His mom is still alive. His mom is going towards her 80s. So those kind of situations, not praying that anybody dies young. It's our prayer and our hope and our wish that we live long, a fulfilled life. But some people don't get that privilege. Some people die in their early age and they would have been achieved. They would have, had achievements, had children, and they live aged parents, children with special needs. So things like dependent trust will work for them. You have things like endowments and foundations. You have retirement trust, wills and executorship, sorry, and nominee and blind trust services and products. You also have family office. Family office would help you to include governance frameworks for intergenerational decision making. So beyond creating a will, beyond creating a trust, you want something that will manage your entities, your business interests, such that it's like a private office. Some of us know a few of these offices and it works. Trust me, a well-structured works. It would include governance frameworks, investments, and performance oversights, structures for giving, foundations, mission-driven interests, coordination of legal, tax, and fiduciary services across jurisdictions. So, in that office, it would employ tax professionals, legal professionals. There may even be an executive, a CEO to run it. He just makes sure that the entire affairs of that person, maybe the person has now grown his business to a level where, he cannot now manage it as a simple business or use a trust, then you can use a family office. And of course, offshore trust for some of us who have assets abroad, an offshore trust will work. Just going to now delve into a few stories which I feel will resonate with most of us and give us a deeper insight of why it's important to use estate planning to preserve and protect your legacies. The first story will be about Barry White. He is a music icon here, or he was a music icon and a music sensation. Um, he was estranged from his first wife. Um, they had lived together, fell apart, but somehow they didn't file their divorce proceedings. They didn't go through their divorce proceedings. And by the books, on record, they were still married. Now, despite being separated to this person, he was now with another person, a partner, we'll call her a long-term partner, and he was with her for years. Even when he fell sick, she was the one with him. She was the one living with him. She was the one taking care of him. And he now died. So when he died, he was still married to his first wife, whom he had parted ways with a long time ago. For some reason, he didn't update his status. He didn't say, okay, let's file, let me marry this next person, or let me create a will or a trust, to cater to these other people. So typically, the courts now decide that it is your wife on record who is now going to be the person to manage your affairs or to direct your affairs. She's now the one in charge of your estate and everything you own. We can all imagine how rich or how wealthy Barry White would have been, the royalties that will still be coming into that his estate. Now, the downside of that arrangement or that situation is that the person who he loved and wanted to provide for, he couldn't now provide for her because his wealth, his money had now gone into the hands of somebody that, oh, he didn't think or he didn't want his money to go to. He had already quarreled with her. He had already moved on from her. And the person who he now wanted to provide for, he couldn't provide for her. Now, had he had even as simple as a will, things would have been put in perspective. Would have understood, okay, this is what he wanted us to live by after he had gone. Whitney Houston, she had an estate plan. She created an estate plan before her child was born. If you recall earlier, I mentioned updating your estate plan as your life circumstances change. This story would teach us why it's important to always update your plan as your life circumstances change. She created a plan before her child was born. After her child was born, she had issues with her then husband and they parted ways. And part of what she said go to her child is, oh, okay, at a certain age, I think it was 21, the child was going to receive a portion of the net worth of what was willed to her, what was, supposed to go to her as a beneficiary. Then after, I think it was after a year or so, another portion was the remaining portion was supposed to go to her, to the child. That child grew up under circumstances that we all know about. There were drugs, there was fast life, no proper guidance. And what she saw her mother do is what she felt was, the right thing to do. After she got the first portion of her inheritance, a year after was when they found her in the tub when she OD'd and subsequently she died. So now the estate has now gone to the remaining part of with the Houston's family, her mom and her siblings. What was structured from a place of love now turned out to be a tragedy, a tragedy. It's supposed to be a watertight situation. So that's why you need professional hands one. That's why you need to update your plan. Say she had realized, okay, I'm no more married to Bobby Brown. That should have been taken care of at the point of divorce. At the point where she realized, oh, okay, I have this issue, I have this problem that is most likely going to send me to an early grave. Who should I put this child in, in care of? Should I not restructure this giving? Should I not make sure things are in place so that this wealth does not even kill her before her time? So those are the things you should put in consideration when you want to give. Yes, you're coming from a place of love, but there's sometimes some circumstances that you should think about tough love towards your beneficiaries. Gani Farimi, his will is public knowledge. If you Google it, you see a copy of his will, very detailed, provided for his trust and his publishing empire, same with Obafemi Awolowo. There's little or no rancor around these two people. So if you just go Google it, it's public information. You see, these are two examples I would like to give. I'm sure some people will be wondering, okay, it's always issues of when the person writes a will that they go to court. How about a trust? Are there issues where somebody has created a trust and they are being sued, the people in the estate, the beneficiaries of the estate are being sued? I'll give you a very good example. There's somebody called Jimmy Buffett. A few of us will know who Jimmy Buffett is. He's a music icon. He's the name behind Margaretaville. He died in 2023. He had a trust. So what seemed to be a very watertight plan. He had his wife and his best friend, his longtime friend or a financial advisor as trustees to his estate. So that's another reason why you should consider using a corporate trustee so that the individual elements, the concern about individual trustees, you can, bypass all those kind of issues. So he put his wife and his trustees. Today, his wife has sued his friend. Now, why did he put his friend as a co-trustee? He felt that his wife had spendthrift tendencies. So he said, okay, my friend will be there to checkmate her. So now she's bringing bills and saying, give me this, give me this, give me this, give me this. And the friend is saying, no, this is what the settlor said, this is what the settlor said, this is what the settlor said. It's quite rare, but there are instances, one instance where even though it was a trust which should have been built on privacy and confidentiality, it has gone to court. One thing I didn't mention about what a trust prevents you from is from it can prevent you from creditors. You can a trust if your assets are being owned by a trust, it can prevent you from it can even prevent you from issues where or situations where okay the person is married and they're splitting assets, sorry, going through a divorce and they're splitting assets and your asset is in a trust or is being covered by a trust. If it doesn't fall under what you own, it cannot be shared in a divorce proceeding. So back to my GB Buffett story. Now they're in court. what should have been a proper structure or a correct structure, but because he did not consider or envisage, he just did it from a place of emotion. The structure was not proper, which is what FATL can help you do, depending on your own family dynamic and your own unique situation. So I'll move along. Um, okay. we all we spoke about different aspects of our business, which may not really pertain to the topic for today, but briefly, I'll tie it back to a family office. Most of us have businesses and business interests. A family office might work to help you structure and help you preserve that legacy, protect it, to ensure that businesses you had, okay, things like you see so many businesses in Nigeria that maybe biscuit businesses, those kind of old businesses that all the founder needed to do is to create a structure around it, an office around it, a trust structure that the trust now owns the business and the business interest, such that if their children now want to become directors or they want to work in those institutions, there are now criteria that the settlor has now set. They have to fulfill this, they have to have done this training, they have to have done that, they have to have fulfilled. So you don't just come and just say, because it's my father's business, I'm going to waste the money, I'm going to be buying what I want. I have to be traveling abroad. There's structure in place. So for your business interests, for your businesses, because some of us have various businesses, you can use a trust to hold this interest to ensure continuity. I think I'll just take the last slide as um, as we go on. It's important for us to continue to think about, because it's a conversation we don't like to have, but it must be had because it's inevitable. Death is inevitable. Even though we don't like self-care, but we have to tell ourselves the truth. Each of these plans can be uniquely tailored to suit your needs, to suit your objectives. You want to be able to consolidate all you have under one umbrella such that it works for you now, it works for your children or your loved ones, and you can be able to, it continues to live after you're gone or in case of incapacity. So if you have different businesses, you are somebody who likes to take risk, or you have this, you're in this venture, you're giving this startup money, you're giving this business, or you also want to do charitable giving. You also want to provide for your children. You also want to provide for your children's children. So you have a trust to own these business entities. The business entities, the monies that come into the trust from these business entities, say profit, revenue, dividend, whatsoever, goes to fund this foundation or this charitable giving, where you would have already stipulated in a trust deed, this is what you want to give, this is how you want to give. And then also cater to education of your children and their children, their welfare, their upkeep, their accommodation, their stipends, and the whole idea of how you want to live, the legacy of giving, continuous giving. In my community, I want to be giving scholarships, so my trust will continue to do that. I want to organize lectures. I want to speak about estate plan. I want my community to know me as somebody who does this lecture. So in my honor, every year a lecture will be done. In my honor, I give 10 high good performing students scholarship. Those kind of legacies that you think about that you want to do and you're wondering, how can I get this going? How can this be? How can this be? I want to live by it. I don't want to go and then my family is now fighting. And then one myth that I also like to speak on before we end this session is, it doesn't have to be when you are old. Don't think about estate planning from a place of, oh, it's when I have children. I don't have children now, so it doesn't pertain to me. Or I'm single now, it doesn't pertain to me. Or I'm still in my capital or wealth building and gathering phase. No, you can start to think of these things now. We did an analysis, and there's some data that provides that there's even been a shift as to who HIs, ultra HNIs are now. The age bracket is no longer the 40 something to the 60 something. You now see even 20 something year old billionaires these days. And most of them, some of them are not even people who inherited wealth. So some people might even think, okay, maybe they're from a rich background. No, no. So you need to start to think about estate planning from even from now as you think you are gathering wealth. So I'll just stop here so that we can take comments and contributions. I believe I'll be able to throw more light on why it's important for us to build or to create an estate plan around our wealth, consolidate our assets under one umbrella such that we can protect what matters and preserve our purpose and our legacies. Thank you very much. We'll take questions at this point.
Okay, so good afternoon, everyone. We were taking the questions, so we already have some questions that some of us have already asked. So we'll be starting with those. And then if you have any other questions, you could actually continue to add them on the question and answer block, and then we'll be answering them as we go. So our first question is from our anonymous attendee, who is asking, is it only a lawyer that can prepare a person's will that a probate can recognize?
Okay, trust houses in Nigeria are licensed to create wills for people. So, aside having lawyers on our team, we can also prepare your will and to be recognized at probate. You can lodge it at probate, even though it's prepared by the trust house.
So our next question from Prince Sawyer says, does a deed of gift have to be registered with a government institution? And how can one authenticate a deed of gift?
So with a deed of gift, it's like re-registering the property. Think of it as a transfer. So if you were doing a sale, the person will still have to go back to the registry to register their title in their name. So with a deed of gift, we'll have to go pay token because it's given out of love and mutual affection. So there's no consideration per se. So yes, you will still need to register the deed of gift to reflect the new owner of the asset and it can be authenticated. Yes, you have to register it at the probate registry where the property is situated.
Okay, our next question is from John Anyanwu, who says, after setting up a trust, I assume all your assets belong to the trustee. My question is, how do you maintain your lifestyle from the trust? And then there's a second part of the question that says, can you use your assets in the trust as collateral?
Thank you, John. After setting up your trust moves to the trust. Now, there are two different structures you can think of. I'll just try not to confuse you too much with too much technicality. So there's the private trust that can be held by First Ally Trustees as licensed trust practitioners in Nigeria. And then you can use an SPV or what the people abroad call the LLC to now hold the trust. So that LLC owns all the assets. So think of it like this. Simply put, your trust, not First Ally Trustee, your trust owns the assets, owns the title of the assets. This is so that it can easily transfer. Now, how do you maintain the lifestyle? Remember, I said it is called a living trust. So, whilst you are alive, it caters to you as the primary beneficiary. Whilst your beneficiaries, your other beneficiaries, your children, whosoever, become the ultimate beneficiary. So, in your lifetime, it can maintain your lifestyle. So, if you want to set it up and say, I want to move money to myself. I want a payout every month. I want you to pay for this vacation expenses, whatsoever it is that you want to stipulate. The trust can take care of you. So you are the first beneficiary of the trust. Now, your second question, or the second leg to your question is, can you use your assets in the trust as collateral? Absolutely. But the downside is that because there will be a charge or a lien over those assets, it can't move to your beneficiary until you fully liquidate your obligations, your financial obligations. So there are two ways to look at that side of your question. You could remove some assets and then create a corporate trust So I'm assuming that you want to use the trust for working capital needs. You want to use the borrowings for working capital needs. So if you can remove one asset to use as collateral, yes. You could also use the assets in your private trust. But like I said earlier, the downside is that if you don't fully liquidate or pay up those your financial obligations, your beneficiaries cannot now enjoy the value of those your assets. Thank you.
Okay, our next question is from William or Ayangile. What happens if a corporate trust goes bust?
So because we're regulated by the SEC and the trust deed which we draft to govern the trust structure always provides for a successor trustee, which, it's always under the purview of the SEC. So if, quote and unquote, a trustee goes bust, there are always provisions and there are always situations where a successor trustee can take over as the SEC would direct. So you have nothing to worry about.
Our next question is from Madhukar Kafo, and his person's asking, do you need to notarize a will before it is legal?
Not necessarily. No, you don't need to. Once it's properly franked, we can determine that the settlor did not write his will under duress. You don't need to. You just lodge it at the probate registry.
Next question is from an anonymous attendee. How can I have a trust if I have an investment with four different brokers?
I want to believe that for the brokers you wrote here, you mean four different investment houses. I want to believe that's what that person is saying here. So how can I have a trust? Now, if you create a trust today with First Ally Trustees and you have four different type of investments with four different investment houses or four different brokers, as you have put it, you would notify these your brokers of the existence or the creation of a trust. One way to look at it is you can move everything to one um to the trust. One, you can move everything to the trust. One, two, if you are somebody who has concerns about concentration risk, you can leave it with the four brokers and notify all those brokers to say, I've created a trust with First Allied Trustees as of today, and in case anything happens to me, everything that I own will be moved to my trust, who will now administer it for my estate. Another way, another way I can explain that part to you is sometimes you see people who take life insurance policies and they will now put the trustee or the trust as the beneficiary, such that when the money now comes to the trust will now follow the trust deed to now share the proceeds to the beneficiary. So think about it like that. You can notify all those houses to say, this is where I want to do it. And if you feel like, okay, that's a bit clumsy, you can then just move everything to one house, which is the trust. Next question, please. Are there any other parties involved in the trust? Yes, there are other parties involved. You have the designated representative. And if you have minors as the beneficiaries, you could also introduce or include guardians. So you could also have in a structure, you could see beneficiaries, trustees, the settlor, designated representatives, and guardians. Thank you.
So the next question is, when you issue a power of attorney to an individual, how can you safeguard it from abuse by the administrator?
I mean, to safeguard it from abuse is to constantly monitor. Um, I've always mentioned, I've been mentioning on this call that if you're not comfortable, if it doesn't suit your purpose, don't choose that plan, don't choose that tool. You can't really you can't really control how a person will react. You can stipulate what the person can do, you can control, you can, continue to, because there's definitely be instances where the person will want to do what you've not authorized them to do. So if it doesn't work, if it gets to that place, you can cancel it, you can revoke it rather. So there isn't really one plan fit all method of controlling it in different circumstances. But I'd like to say that if it doesn't work, a trust will be most likely suitable because you have a corporate trustees, you have regulators who are on their back, so they won't want to, stain their reputation. Thank you.
Okay,
Okay,
then the
you say
next question is, if the settler still has control of the trust and benefits from the trust, isn't there a risk that creditors can attack the trust?
so. Creditors cannot come after what you don't own. Creditors cannot come after what you don't own. So you must create it. You see, having professionals guide you is very important. You must create it to be watertight in a way that if it's not you, that you cannot give what you don't have. So if it does not belong to you, creditors cannot attack it. Yes, you may be able to give, when you say control, you will not maybe investment decisions, and the likes. But as to determine to the ownership of it, what the creditors will come after is what you own. So if the assets under the trust are technically not yours to give, they can come after it.
Okay, the next question is for trust and wills, where you have assets in different jurisdictions or countries, can a single document suffice?
A single document may not suffice because you have different climates, you have different regulations, you have different tax obligations. So what we typically advise, you create a Nigerian leg and you do an offshore leg. Maybe you create it in a tax haven and then consolidate all your assets abroad. So a single document may not suffice because sometimes you have to now go and still obtain probate abroad after obtaining probate. If it's a will, you obtain probate here and obtain probate, which is really lengthy. Sometimes it goes as long as a year or more, trying to just get the document that will gain you access. So why not just create a trust here, a Nigerian leg, that will now feed into an offshore leg, which should be tidy and should work in most circumstances. Thank you.
The next question, are trusts legally registered and recognized legal entities? What are the typical tax implications for setting up a trust in Nigeria? And can a Nigerian trust cover assets even outside Nigeria?
So the typical tax implications would be the income tax. You would also see things like some jurisdictions abroad would still tax you for inheritance tax. I think in the UK, most especially, you don't really care whether it's owned by a trust or an individual, they will still tax you. So a trust legally registered, yes, you can register a trust legally in Nigeria. But in Nigeria, the concept we usually use is to have a private trust with a licensed trust house. You have a private trust in a licensed trust company, or the other way which I mentioned, which is having an LLC own the trust, which will still sit with a private with a trust house. So for this side of it, you have to have it under a regulated entity like First Ally Trustees. So can a Nigerian trust cover assets abroad? No, because of the tax implication and because sometimes when you want to remit money out of the country, they're always big on, even in Nigeria, they're always big on proof of funds. They always do the due diligence. So if it goes through that, like if you're remitting from here abroad or vice versa, there's always that ask of where are the funds from, where are the source, what source of the funds. If they realize that it's from a trust and that jurisdiction has taxes that deal with inheritance or things that come even to a trust, you will be heavily taxed. So structure matters. Your assets, of course, your assets will determine what structure you pick at the end of the day. Okay.
Okay, so we have some other questions that were not in the Q&A, so I'm just going to try and pop some of those. Says that can we have one trust to cater to up to 3 to 4 needs rather than having several trusts?
Absolutely. One trust can cater to education, One trust can still cater to education, whilst catering to education can cater to retirements, dependents, and what have you. One trust can, of course, it can cater to several objectives. Yes, and it will be stipulated clearly in the trust deed what it will cover. As I like to say, the trust fund must always be sufficient to cater to each objective that you have placed down. So if you have 10 children and you still want them to go to school abroad and you want to still do charitable giving for 100 students, the trust fund must always be able to cover that objective or those objectives that you have stated in your trust deed. So to simply answer your question, a big yes, one simple trust can cater to different or several needs.
Okay,
I see a
this is
question there. Go ahead.
okay. Learned it's quite expensive to set up a trust, and one needs to have accumulated huge assets to qualify or for it to make sense. Is it possible to get the cost implication for both the will and trust? This will help in the decision-making process.
Absolutely. If you could please share your details, we could share that information with you after the session. We would also include the costing. Of course, when we speak to you, we'll be able to determine, what will suit your needs, and of course, we share the cost implication of both plans. So if you could please share your contact details, your email or your phone number, we would provide that information immediately after this session.
Then someone is asking that for those in the diaspora who are often torn between investing abroad or back home in Nigeria, could we please consider a session to discuss some examples of financial products, investment options, or asset types that might be worth considering in these circumstances?
Thank you so much for your feedback, Biodun. Is something that we have products, we have dollar products that people in the diaspora, we have diaspora trusts that people in diaspora can also key into. We have financial sessions that that can cater to these needs. And definitely, if you want us to engage you on a personal note, we'll engage you after this call, whilst also preparing to invite you for these kind of sessions that we believe will speak to your specific needs. Thank you.
Okay, I think we're just going to take like maybe one or two more questions. We still have quite a number, but it's already 12, so we just want to respect everyone's time. So uh, so yes, so the next one is someone now asked, what is the frequency of surviving family members legally challenging will and trust and instructions left behind by the deceased, or is it rare?
Or first of all, when there's no plan in place, you see more chaos. Where there's neither a will or a trust in place, or a part of or a deed of gift or whatever in place, there's usually a lot more chaos. That's when you start seeing they'll say, this person is not the child. Let them go and do DNA. Let the wife come and do this. I know one time they were fighting. Those kind of situations, there's a lot more chaos when there's no plan in place. So that should be the first thing you should think about. Now, for the will, there's always a lot more buzz, a lot more people running to courts to challenge validity, even sanity of the person who set it up, medical stance of the person who set it up at the time he wrote it. You see that more with wills than with trusts. Trusts are more private, more straightforward, more direct, more easy. They are easier. There are lesser situations of challenging, what the person has stipulated when you come to trust is like the probability of people challenging an estate plan is higher when you speak to wills than with trusts. So yes, it's not rare. It happens because we're human beings. People always feel cheated, even when they're not cheated. So you see it a lot more with wills. But of course, it's worse when there's no plan at all in place. If there's a plan in place, okay, to now be subject to interpretation by, the governing authority or which will be the courts at the time. But if there's no plan in place, that's when you see a lot of drama. Okay, Funta.
All right. Thank you very much, everyone. Thank you very much, Nwamaka. We've been getting some questions, people asking if we will have the recording of the session will be made available to everyone. Yes, we will make the recording of the session available to everyone, as well as the slides during the session, so you can go through it at any point in time that you wish. We have also dropped a link here for anyone that's interested in any of our services or has further questions and would like to inquire more about our services. We've dropped a link in the chat. Please feel free to fill out the form and a member of our team will get in touch with you. Thank you very much for spending this time with us. We hope that it has been a rewarding session for you and you have been able to gain some knowledge into this, into trust and wills and everything about this. And we look forward to similar sessions in future. Thank you very much, everyone, and do have a good rest of your day.